Hello, my name is Jo Howcroft and today I'm going to talk you through a series of slides that will help you to understand how to assess that somebody has the capacity to make a decision and how we decide on the decision that would be in somebody's best interest if they lack the capacity to make the decision for themselves, and also which decision would be the less restrictive option. This presentation is aimed at people living in a care home environment. It is easy to make decisions that we believe would protect somebody from risk or think what is in a person's best interest. When we support our loved ones to make decisions, very often we focus on what our own beliefs and values are and also try to protect our loved ones from any risk that could be as a consequence of their decision. The Mental Capacity Act sets out a legal framework to follow to help support people who lack the capacity to make their own decisions. It helps us to put the person at the centre of the decision-making process and not put our own beliefs first. This can sometimes be very difficult, particularly when we are governed by emotion. The Mental Capacity Act that was introduced in 2005 and implemented in 2009 sets out 5 principles that must be followed. Firstly, we have presumption of capacity. Whilst this seems quite simple, just having a presumption of capacity, particularly in a care setting, could mean that we don't follow the duty of care that we owe to a person under other statutes such as the Health and Social Care Act 2008. Following the Mental Capacity Act framework can protect healthcare workers from liability if things go wrong. The 2-stage test set out on the Mental Capacity Act is a positive test. We apply the test to try to prove that somebody has capacity to make their own decision, not try to prove that they don't have the capacity. Following the assessment process helps us to ensure that the following principles are adhered to. By this, I mean supporting the person to make their own decision, supporting somebody to make what we would consider an unwise decision by providing all the information to help them reduce any risks attached. For people that lack capacity, we need to make the decision that is in their best interest, and that decision must be the less restrictive option. By following the process properly, it is less likely that somebody would be deprived of their liberty, which impacts on their human rights. Think about the 4 fingers and thumb on the hand when thinking about the principles. Presumption. The thumb wraps around the hand to make a fist. Support. Unwise decision. Best interest. And then the little finger as the less restrictive option. The 2-stage test starts with stage 1, which sometimes is referred to as the Diagnostic Test. It asks 2 questions. Firstly, does the person have a mental impairment that is impacting on the function of their mind or brain? And secondly, is that impairment impacting on the person's ability to make this decision at this time? Stage 2 is the functional test. It is the part of the test that helps us evidence how the impairment, if it does, impacts on the person's ability to make a decision. It requires that we establish how the impairment is impacting on the person's ability to make the decision by establishing the following. If the person can understand the relevant information to make the specific decision, can the person retain the information to make the specific decision at this time? Can the person weigh and balance all the consequences of making the specific decision? And can the person communicate their decision using any means at all? I'm going to break each part of the test down to help you look at what is required to carry out an assessment. If you remember in slide 4, we mentioned the diagnostic test. We are not diagnosing a person. We are trying to establish whether the person has a mental impairment at this time. The mental impairment does not have to be a diagnosed condition, nor does it have to be a permanent condition. Here we are looking at some temporary conditions. We need to think about in these situations if the decision is required at this time or whether it can wait until a person has regained capacity. For example, if we look at drug and alcohol intoxication, some decisions can wait until the person has regained capacity, particularly if they sober up in a few hours. Although delirium is a temporary condition, the symptoms of delirium can last for several months until the root cause has been treated effectively. It may mean that some decisions can't wait until the time that a person has recovered. Therefore, if the person is assessed as lacking the capacity, we may need to follow the best interest decision-making process, which we'll come to in slide 15. Some permanent conditions may mean that capacity can fluctuate. In these situations, the capacity assessment would be carried out at the specific time that the decision is needed to be made, the same as with decisions that are required at the time a person may have a temporary impairment. Dementia is progressive and currently there is no cure, nor is there for some mental illnesses. Acquired brain injuries can improve, however there may be concerns over capacity to make some more complex decisions. If a person does not have a mental impairment, then the Mental Capacity Act does not apply. When we have established that a person has a mental impairment, we need to identify how that impairment impacts on the person's ability to make a decision. Somebody with dementia may have difficulty with the memory, which impacts on their ability to retain or recall information required to make a decision. Somebody with an acquired brain injury may have difficulty processing information, and this impacts on their executive functioning for carrying out complex processes. They could be impulsive in their decision making, therefore struggle to make rational and logical decisions. A person who is unconscious is unlikely to be able to communicate their decision. If a person does have a mental impairment and you reasonably believe that the person is able to make the decision and manage the risks involved in making the decision, then the person under the Mental Capacity Act is deemed to have capacity. For people whose decisions involve risk in a care setting that do not have a mental impairment and provision of information and alternative options to mitigate risks is not accepted, it would be appropriate to follow local and company safeguarding policy and protocols. When we have identified that the person does have a mental impairment and we reasonably believe that the decision is impacting on their ability to make the particular decision at the particular time, we would move on to the functional part of the test. This means that we need to answer the 4 questions with a yes for the person to be deemed under the Mental Capacity Act to have the capacity to make the specific decision at the specific time. I'm going to break down the 4 questions to help you to make an assessment of whether the answer is yes or no. Let's look at what the threshold for understanding is. The threshold is set by case law and talks about the reasonable man. By reasonable man, we would question what somebody would be expected to know at the level they are at. For example, we would not expect a patient to have the same understanding and level of knowledge as a nurse or a doctor. The same applies in a care home. A resident in a care home would have been provided with information when their medication was prescribed. The information may include side effects and what condition the medication is being used to treat. As with many people, medication names could be quite long and difficult to say. Therefore, a person may identify their medication by the shape or the colour. If we look at just a few of the decisions a resident is likely to make in a care home and what information would be relevant. Living in a care home. The information to understand is outlined in case law and includes things like the person should know the name or the setting they will be living in, and they will be living in the same environment with other people who are not family members. They may need to know that the doors are locked and that they would need to ask somebody if they would want to leave. What to wear. Somebody would need to know what the weather is like or what is appropriate for the environment that they are in or the activity they are going to do. What to eat and drink. Allergies would be extremely important to know. What their likes and dislikes are. Any condition that might impact on their intake which place the person at risk, such as choking, or a diagnosis such as diabetes. If the person wanted to refuse to take medication, They would need to know what the medication is needed for. This does not need to be in medical terms. They would also need to know what could or is likely to happen if they don't take their medication. Setting the threshold too low or too high may mean that some people could fall through the net and may come to harm as a consequence. If somebody doesn't have the information, then we need to provide it. By doing this, we're providing support to make the decision, but also enabling us to assess the person's retention of that information. When thinking about retaining the relevant information, we need to think about the decision at hand. There is a difference between making a decision that involves a process to one that is making a simple choice. If we look at the slide, I have put both a complex decision and a simple decision. Firstly, we'll start with the complex decision. I need to pay a bill, so I need to get money out of the bank. Getting money out of the bank requires us to follow a process, which means that information would be needed to be retained for a longer period. Can you imagine setting off to the bank and getting part way there because you know the way, then stopping at a junction and forgetting where you are going and for what purpose? If you have to pay a bill that day, your retention of information would impact on you being able to do so. We then have simple decisions or choices, such as what we want to wear or what colour we want to wear. Again, as said at the end of slide 11, provide the information. We may have to provide the information several times to support the person to make their own simple decision. Weighing and balancing the consequence of making a decision is probably the most difficult to assess. We do not want to prevent people from making their own decisions. However, we also need to ensure that we have supported the person to mitigate any risks associated with that decision. When looking at this part of the test, we would look to establish whether the person has been given the same information as you or I as a member of the public, whether the person can use the information to follow a logical process to come to an outcome, and the outcome is different to one that you or I may make and could contain risks. If the decision involves risk-taking, this is likely to be considered as an unwise decision. The Mental Capacity Act is very clear in stating that people should not be considered as lacking capacity purely on the basis that they make unwise decisions. Consider things such as lifestyle choices, such as smoking, drinking alcohol or taking illicit drugs. Do we have the right to remove a person's lifestyle choice because we want to protect the person from harm? We need to consider whether us protecting the person is proportionate to the significance of the harm. Smoking can cause cancer, but the person has smoked all their life. Think about the lady with dementia who wants to continue going to the luncheon club. For this scenario, the lady will be called Elsie. Before her symptoms of dementia deteriorated, her preferred mode of transport would be the bus. She now finds it difficult to find her way around the local area, but can still communicate and enjoy spending time with others. Do we say she doesn't have the capacity to decide to go to the luncheon club, or do we support her to make her own decision to attend? The decision in this scenario is not to go to the luncheon club, but deciding to use the mode of transport to get there and back safely. We could offer different form of transport, such as a taxi there and back. We are not in this situation restricting Elsie's freedom of movement. The acid test was outlined in the Cheshire West case in 2014. This determines what would be required for a person to be considered to be deprived of their liberty. The acid test states that a person is deprived of their liberty if they are subject to continuous supervision and control and are not free to leave. When answering both questions, staff should consider if they exercise complete and effective control over a person's care and movements and decisions about their care. A person does not have to be asking to or attempting to leave to be deemed not free to leave. Care staff should ask what they would do if the person tried or asked to leave. If the answer is that they would stop the person, then the person is not free to leave, within the meaning of the acid test. This means that if someone lacks mental capacity to consent to reside, for example, in a residential care home or hospital ward, and they also meet the acid test as described above, then a request for a dole's authorisation may be required. If we go back to think about Elsie, if risks are quite significant, for example, her concentration and memory deteriorate further, resulting in her wanting to leave before the taxi arrives, we are likely to make a best interest decision, weighing all the different options to enable her to continue to enjoy other people's company at the luncheon club, by either a person remaining with her throughout or bring the luncheon club into the home. In this situation, we would be restricting Elsie's freedom of movement. This would require an authorisation and would be applied for under the Deprivation of Liberty Safeguards process. It is the responsibility of the registered manager to ensure that the dole's processes are followed properly. All 4 parts of the test need to be answered yes for the person to be deemed to have the capacity to make a specific decision at a specific time. The person must be able to communicate their decision by any means possible. In a care setting, there are several ways in which we must support our residents, and we must adhere to the NHS Accessible Information Standard. The standard sets out a specific, consistent approach to identify, record, flag, share and meet the information and communication support needs of patients, service users, carers, parents with a disability, impairment or sensory loss. Some examples of how we can ensure we meet this standard are writing things down, offering choices using pictures, using technology, using large print, using the language that the person understands, using Braille. This list is not exhaustive. Speech and language therapy teams, sometimes known as SALT, can support you to develop communication strategies to help an individual. We must do everything we can to help the person make their own decision. When we have completed stage 1 and 2, we should make sure that the assessment, findings and outcome are recorded. There are 2 ways in which this will be done. For simple decisions, a record would be made in the daily notes. For more complex decisions, a record will be made on the organisation's formal document. If the assessment outcome is that the person has the capacity to make the decision at the specific time, there is no requirement to make a best interest decision. This is an example of a simple entry that you would see written in Elsie's daily notes. Elsie refused to be assisted to transfer into a chair. Elsie didn't understand that she was not able to walk without assistance, she may fall. I told Elsie that she may fall without support several times, but she couldn't remember what I was saying to her and continued to refuse support. It was decided following discussion with the person in charge and Elsie's relative that it would be in Elsie's best interest to refer her to a physiotherapist to see if there was an alternative support that we could use and whether there is another less restrictive approach we could use to help her transfer into a chair safely. We are now going to look at the best interest decision making process. Remember though, we would only do this when a person has been assessed as lacking the capacity to make their own decision. Best interest decisions are not always those that the person would have made, nor are they the decisions that the next of kin has made. The process to follow is much more than this. Best interest decision making means that we are placing the person at the heart of the decision making process. If the decision can be put off until a time when the person regains capacity, then this should be done, particularly for people who are considered to have fluctuating capacity because of the symptoms of the condition. We are considering all the relevant information about the person's past, present, wishes, preferences, beliefs and values. Information will be obtained from several sources, not just the individual. Information from care plans will be used, and this is why it is extremely important to make sure that documents in the care plan is completed in full and is accurate. Other relevant people should be consulted with, such as other professionals, family carers and advocates. People that must be consulted to enable a best interest decision to be made are people with lasting or enduring power of attorney and court-appointed deputies. In slide 12, we looked at different types of decisions, simple and complex. A simple decision is likely to be an everyday choice that is made, such as what to eat and drink or what to wear. A complex decision is one that could be challenged by another person. We need to make sure that we provide evidence of the process that we have followed to make the decision and how the decision is the less restrictive option. Remember in slide 3 when I talked about duty of care. To enable us to evidence the process we have followed, we can use a table format. This has been referred to as the benefit burden model, but in simple terms can be a pros and cons table like this one. We look at all the options that are available for the person, particularly where a restriction may be required to mitigate the risk of harm. In this situation we are going to look at Billy. Billy is a high falls risk, and at night time he likes to get out of bed and walk around the lounge for a while before returning to bed. For this scenario, we will consider Billy being a security watchman who spent his lifetime working nights at a warehouse. We need to make sure that Billy is restricted as little as possible, but at the same time try to reduce the risk of a fall that could result in harm. An analysis of Billy's falls has identified that most of Billy's falls are during the night time when he gets up. We need to look at the benefit of the options or pros and the burden of the options or cons. There is no right or wrong answer, and it is quite often good for more than one person to go through this process with you following this model. By following this process, you are demonstrating that you have considered all the options available, including any associated risks, and you have given a rationale of what decision would be in Billy's best interest and is the less restrictive option. As with slide 15, the evidence of how the decision has been made will be recorded in the person's daily notes and/or in the organisation's formal document. Thank you for listening to the session, and I hope you've gained some useful knowledge that you can use in your practice. If you'd like to know more about what I do, visit my blog at www.pomehe.com, or you can email me directly at joanne@pomehe.com. Thank you again.